This is Technically Legal, a podcast about legal technology, innovation in the legal industry, and the impact tech is having on the law. I'm Chad Main, the founder of legal services company Percipient, and on today's show, I'm talking to Donald Beshada. He's the CEO of Covalynt. That's a company that's using data science to battle fraud in class action litigation. On today's show, we're going to take a close look at the world of class actions. We're talking to Donald Beshada. He's a former litigator, and now he's the CEO of legal tech company Covalynt. As Donald and I take this closer look into class actions, he's going to fill us in on why it often turns into an expensive game of cat and mouse. This is so because when a company settles a lawsuit with millions of claimants, the goal is simple: get the money from the litigation to the people that were actually harmed. But in an era of automated bots, professional coupon deal sites, and fragmented digital identities, proving who is actually a real claimant has become a multi-billion-dollar question. Don, in his former life as a litigator, saw that lawyers were bringing water pistols to a tank fight, and that tank fight being the certification of class action lawsuits and the administration of class action settlements. So Don decided to do something about it, and he decided to build a tank to battle back against these fraudulent class action claims. In this episode, we're going to hear about Don's career trajectory, from being a BigLaw lawyer to legal tech entrepreneur. He's going to fill us in on why there are different skill sets required for being a plaintiff side lawyer versus a defense side litigator. He's also going to explain the nuts and bolts of class action administration and the evolution of the class action settlement notice, from People magazine to nowadays where his company's providing lawyers with data science outputs. And he's also going to tell us about the birth of his company Covalynt, which is a complex litigation data intelligence platform.
So when I moved over to Drinker Biddle, I met a couple hard-charging entrepreneurial guys that had high-growth marketing companies. And the nature of a high-growth, small startup marketing company is you do a lot of things wrong that the FTC and the advertising laws don't allow you to do when marketing your products. So they got themselves, a bunch of them got into all kinds of trouble in class action work in California and with the FTC. So I changed suits from the employment litigator and became a marketing and advertising lawyer defending class actions.
You had not done the class work prior to working with the marketing firm?
I had done some limited employment class work for a couple of years, but I had done no consumer-based or antitrust or any of what we do today. I had done none of that work before the early 2000s. So moved over to Drinker, defended and did some of those cases for a few years. A made partner, had kind of a personal life experience that my wife got sick and the big law firm thing just wasn't going to end up working out for me. So I left the big firm in the late 2000s and joined a plaintiff's firm in California that I'd been adverse to in a couple of cases a couple of years before. So having a defense background was really helpful to a upstart plaintiff's firm, which was an established plaintiff's firm, but they had been an upstart in doing consumer class actions. So I knew the industry and I sort of knew where a lot of the bodies were buried pretty significantly in the dietary supplement and the sports nutrition space. So I became a plaintiff's lawyer and we started doing some, plaintiff side class action work in that consumer dietary supplement, protein, sports nutrition space. We did well, made some money doing that.
Which do you prefer? Like looking back now, do you prefer the defense side? Do you prefer the plaintiff side, or are you ambivalent about it?
I prefer the defense side. I realized early on that both sides of the equation, they don't have a lot of nice things to say about each other generally, but having done both sides of it, I think that there are just different skill sets that make a really good defense lawyer from what makes a really good plaintiff's lawyer. And those skill sets equate to one another if you're looking at them, from a binary perspective. So the special skills that required one to be a great plaintiff's lawyer were just not skills that I had. The skills that were required to be a good defense lawyer were something that I had.
What specifically were you strong at that you said, hey, I'm better on this defense side versus, my strong suit is this trait I need for plaintiffs. That's not my strong suit.
I think being from a relatively conservative perspective, meaning that, you spend a lot of time turning over every stone and thinking every issue through from an analytical perspective, that I think makes a good defense lawyer. And I was trained that way, in the big law firms. I think what makes great plaintiffs lawyers are they're able to very, very quickly take what I'll call top sheet approaches and run with them and do very well with not necessarily the depth
they're gunslingers,
that is required
right?
on the defense side. Exactly right. And I didn't really have the gunslinger mentality. And so it was, the comfortable old shoe always fits best, right? So it was great. I mean, we were successful being plaintiffs, but not nearly as successful as, some of my now buddies. Scott Burser runs a tremendous firm. Those guys are really, really good lawyers, and they're really, really good analysts, but they have that extra skill set of being the gunslinger that was just not something that was embedded within me. I was more of a business oriented guy.
What did it say? Trial lawyers, never prepared, always ready. Big
Correct.
firm lawyers, always prepared, never ready, right? That's the joke.
That's exactly right. Yeah, it's funny. Mike Griffinger, who was one of my mentors at Gibbons, used to say, as he's going to court, he's like, you can never have enough preparation. I prepared for a week, and I'm preparing, like, you drive to court so I can continue to prepare all the way up to the moment of the hearing, and the plaintiff's guys walk in, like, I looked at the file a week ago, and, and off they go, which, again, it's when you see it happen and you see their ability to talk through those issues, it's amazing. So that wasn't something that completely fit with me. So I had a couple small clients still at that point, and then I met a few others in that, let's call it 2009 to 2011 range, that I started doing some work for. And I just decided that, I was commuting to LA from New Jersey, on the plaintiff side of it. And it was just better off to kind of work from home. And I had a small group of clients, and I had I had 3 young kids at the time. So I wanted to be around for them and make sure that I was home when they got home from school. And, my wife and I were able to spend a lot of time together. And I really wasn't into hourly billing or that kind of stuff. So I kind of, got retainer relationships with a bunch of clients and just started to live kind of a normal life, working out of my house. And we did a few plaintiffs' cases, but we rarely took a case that, I didn't analyze it as a plaintiff's lawyer would. I analyzed the case as a defense lawyer would. So we rarely would take a case that was a complete home run winner, nor was it a case that was a loser. It was, kind of in the middle where you could crank out a nice living, kind of doing a few cases a year and live a kind of a decent lifestyle. My entrepreneurial clients at the time, though, were direct marketing companies that primarily swam in the as seen on TV space. And there were 5 like large as seen on TV companies that existed at the time. And in relatively short order, I kind of became the outside general counsel to all of them. So, my work life sort of shifted to, from working a lot as a big firm, then kind of commuting to LA, but having a bunch of free time while I was home, kind of working from home, to representing a couple companies and having some free time, to now being the general counsel of 5 companies that were extremely active doing all kinds of stuff, and delved into some IP stuff and learned a lot. So I like to use this phrase. People say, what makes you tick? And say, my phrase on life is I'm forever a student. Like, I love being a student, and I'm not sure I'm a really good teacher, but I like learning and I like doing new things. So, the I've seen on TV guys certainly put me through the paces with that, because we learned a lot of stuff and did a lot of big ticket litigation, and they were always involved in a class case here or there. So, it allowed me a lot of background a lot of background to what I'm doing now.
So you started getting these direct marketing companies getting sued. I assume they're subject to class actions. So the company you started, was it called ClaimScore at the time, and then you changed the name to Covalynt recently? Like, what time is this? What's the origin story?
So from like the early, or in the what I'll call the 20 teens, I'm doing this class action work, and I never really was a fan of large administrators when I used them in private practice.
Explain what those are who may not be familiar with class litigation.
A claims administrator is a third party that assists either with the settlement process of class actions or the notice process in a certified class, meaning that they do what exactly it says. They administer the settlement that's court approved.
They're the ones sending the postcards we all get in the mail, right?
That's exactly right. And they take the claims in and they make arrangements to make the payments and all that kind of stuff. So there's a group of large scale administrators. It's not a huge business. There are probably, 50 or so companies that do it. I never was really a fan of the large scale administrators that control most of the business, and not for any other reason other than I'm kind of, when I go buy beer, I don't go to Bottle King. I go to my local, liquor store, right? I'm a small town guy. So I always sort of was a big, smaller entity type guy, because I think even with the big firm, there are certain rules and regulations that are in place that you don't have when you have your own firm. So rules and regulations were never something that I was a big fan of. I thought, kind of doing it my own way was always the good way. So always had a little bit of an entrepreneurial spirit. And that kind of happened. The more I hung out with the as seen on TV guys, I guess in life, the people you hang out with, you have a tendency to take on traits of their personalities from time to time. So I was spending a lot of time with these guys and started to become an entrepreneur. So as I'm litigating these cases with them, a friend of mine who was a direct marketing guy, I said to him, "Hey, I think you'd be a great claims administrator." "What the hell are you talking about?" I said, "There's this business in the class action space that, third party businesses do advertising and they bring claims in and they essentially are managers of class action settlements. And I've got a bunch of cases and a bunch of settlements that I'm doing. I don't think it's hard. You get a couple of people and I can teach you the business. We can do it through cases." And he said, "Yeah, that sounds great." So I put a small claims administrator in business, and he did a great job for me. He picked up the business right away. It's not really all that difficult. Hired a couple of people, and we started doing. He started administering some settlements that we were doing.
When you say it's not that difficult to do it, explain the logistics of it, though. You don't have to get in the weeds about it, but explain the logistics, because you got to find these people. You got to send out a bunch of information. You got to get websites up. Like, what did it take logistically to spin that up?
So I don't know everything since he kind of did it, but the formula was relatively simple. You settled the case. You had to do the SC on TV company had a email or an address list that I sent over to my buddy. He cleaned that list up. He sent out some postcards. He sent out some emails for direct notice. And then since he was a marketing expert, the other thing that you have to do in consumer cases where you don't have all of the contact information, because a bunch of people bought these things in Walmart or Target or whatever, is you do targeted advertising. So, he had a particular expertise since he came from the as seen on TV space in targeted direct marketing. And targeting for people to sign up for class actions is no different than targeting to solicit people to buy your products. It's the same formula that you utilize. So he was extremely good at finding legitimate class members, and he put together very cost effective notice plans that were very targeted to, get people to sign up. And I think it's something that one thing that we need to footnote, remember here, like the world has changed so much in the last 15 years. I'm thinking about the last 30, right? The information that we have access to that are at our fingertips today didn't exist 30 years ago. And 15 years ago, people who were in the direct marketing space knew about targeted marketing and Facebook advertising and that kind of stuff. And it was something that hadn't really taken off in the mainstream yet. And it's certainly something that had not taken off, period, in the litigation space. So when Mark started this company, there was no such thing as electronic advertising. People were still using People Magazine and USA Weekend, to quote, get the word out in class actions. So, Mark started doing this targeted advertising, and, we were able to put together formulas that courts would say, well, I guess this internet advertising gets as many impressions as People Magazine. And since it's more targeted, this seems like a good idea.
Explain why you mentioned the formula. You're going to court. Explain what you're doing and why why the court needs this.
So simple, the way the class actions are settled are a settlement agreement is executed, and because it involves a group of people that are not named people in the litigation, a court must approve it every step of the way. So the way a class action settlement works is a case is settled, the parties agree to a settlement agreement. That settlement agreement is then presented to the court in what's called a motion for preliminary approval. As part of the preliminary approval process, you need to advise the court what the quote notice is. And under Rule 23, you're required to give notice to absent class members. And absent class members are members of a class that are not named as named plaintiffs in the case, right? So, for example, you would have a claim against XYZ company. You're the lead plaintiff. So it's Chad Main versus XYZ company. Chad Main is suing on behalf of himself and all other people similarly situated. In a consumer class action, let's say it's a product called XYZ weight loss drug. You purchased XYZ weight loss drug, which made false claims. You are representing the entirety of everyone who purchased that weight loss product in your name. So there's a lot of absent class members, and you have to get the word out that there's this settlement and that these people are entitled to some type of money.
Maybe they weren't identified because they bought it at Walmart, the ones you just mentioned.
That's exactly right. So you need to go out and try and find those people. And how you do that is you put advertisements out. Again, previous to the tech age, you simply put an advertisement in People Magazine that said, hey, you may be entitled to, compensation from a class action because of XYZ diet drug or XYZ diet supplement. So as we moved into the electronic age in the early 2010s, no administrators were really doing that. They were still using People Magazine and USA Today and USA Weekend and Parade. Those were the ways that you got what are called impressions. And a court requires a certain, quote, reach analysis. So I know I'm speaking a little bit technical, but so when you present your settlement to the court for preliminary approval, the court asks about your notice plan. And your notice plan must be designed to reach a certain number or a certain percentage of the class.
Is there a magic number?
It was 80%. As time went on, that number came down to 70%. So somewhere between 70 and 80% is needed to reach the class. And how that formula is calculated is through what's called impressions. So the old school way of doing it, and this is still the law, and this is still the way things are done today, although things are starting to change a little bit, and we at Covalynt are sort of, I think, leading that charge that this doesn't make any sense anymore. But the impressions and the reach formula are based on circulation rates from paper publications from like the 1980s. And that formula has never changed, even though we're now using electronic notice. What you end up have happening now is, notice is going out, and we're talking about, how many people might see a pop-up ad versus actually targeting people who will not just see that ad, but will ingest that ad and do something with that ad. So back to our story, back in the early 2010s, the Mark Shea of Digital Settlement, the first company that I was working doing this, he was the first guy to actually start doing this electronically. And why was he doing it electronically? Because the as-seen on TV companies that he was working for, doing marketing stuff for, were not advertising in People magazine. They were advertising electronically. So you go to the spot where people would see, where they see as-seen on TV advertisements. You would think those same people electronically would see settlement of class actions involving as-seen on TV products. And he put together this kind of electronic program that we then started utilizing, that was then picked up on by other people. And then it ultimately became mainstream. So during that process, in the beginning, no big deal. You'd see claim rates of 1%, 2%, which is what was standard and what you would see in class actions for years and years and years. And then at some point, that number spiked up to 7, 8, 9%.
Meaning 8 or 9% of the potential claimants in this class action.
Correct. You used to have a claim rate. If you have 100,000 people, right? Your claim rate of 1,000 people would be a lot, or 2,000 people would be a lot.
Instead of 1% of that 100,000 participating, because you do digital, it bumps up to 8 or 9%.
Correct. You started to see this increase. And again, kind of forever being a student and forever being curious, I didn't know why that was. So I'd say to Mark, I'm the defense lawyer for the company. I want to make sure that they're not paying anybody that they shouldn't be paying. I said, can you send me like this list? Like, what's going on here? So the other thing that happened at or around that time is we have these things now out there because we have access to everything, just on a phone. It wasn't always that way. And now there are what I call aggregation websites for class actions, which are things like Top Class Actions and classactions.org. And they publish when class actions are settled, because the settlements are a matter of public record. They publish, here's a settlement, here's the requirements, here's how much money you can make, and here's a link to the settlement website. It's the other thing that a settlement administrator does. They put up a settlement website, and then class members go to that settlement website and fill out a form. And that form is what allows you to make a claim in cases, right? So, these aggregators began doing business in the late 2000s, early 2010s. And it was free money. So, you'd see people advertising, free money for this settlement. All you have to do is fill out a claim form. No proof of purchase is required. And you fill out this claim form and you can get $25 in the mail, 6 months from now. So what we discovered as these claims rates were ticking up, and I'm looking at these things, I'm like, well, where are these, the claims were coming in clusters. And then you'd see, things like an entire apartment building would be making claims. And so it seemed strange to us. So we started to dig into the data with pencil and paper, kind of going through, well, what about this? What about this? What about this? And you saw that a lot of these claims just didn't seem legitimate. So we started to track, it's a step-by-step process. Nothing in the law happens overnight, right? I like to say, like, the law is 5 to 8 years behind the real world because everything moves very, very, and as a former litigator, I'm sure you can appreciate that, right? Everything moves very slowly. Nothing happens, instantaneously. There's a lead up to a crescendo. The crescendo happens and then things change quickly, but that lead up to the crescendo happens over time. So, over a period of like 2 years, we saw this uptick. And again, as I said earlier, what makes a great defense lawyer is you pay attention to the smallest of details. I think what makes a great lawyer is actually you pay attention to the smallest of details. And as you're looking at this, I always felt that my obligation as a lawyer was not to just tell the administrator, okay, take a look at this, but I felt I was obligated to kind of look at all the stuff on my own, whether I was getting paid for it or not. I was entrusted with the process. So you have to manage the process down to the smallest detail. So as I'm looking at these claims, we started to, kind of aggregate the claims over time, and you'd start to see, oh my God, in the class case we did 2 years ago, we've done four since then, and this is now number six. And the same 500 people make a claim in all six of these cases. And then you start to peel back the layers and say, well, where are these claims coming from? And then you start seeing claims. Back then, you couldn't hide your referrer URL, right? So the referrer URL would be coming from top class actions or be coming from classactions.org. I said, well, wait a second. These people maybe weren't purchasing these products. These are people that are just making claims because it's free money. Then you started seeing things. Probably my favorite aggregator website was something called slickdeals.net. And it was a couponing website. So you start seeing these claims being made from couponing websites. And it's like, oh my God, people who are couponing for a living are seeing these class cases and they're treating them like coupons and getting paid. And like your side hustle is, getting paid in class actions, whether you purchase the product or not. So, I said to Mark, like, look, we got to put a stop to this. So we started to do some rudimentary things with pencil and paper. Like, we put in an interstitial page that, if somebody came from top class actions, we knew the referrer URL, and we were able to kind of take that and put in an interstitial page when somebody came from there saying, you're coming from a website that advertises free money and may involve fraudulent claims. We're just reminding you that you're signing a claim form under penalty of perjury. And if necessary, we'll prosecute. We find that out. So that acted as a deterrent for a short period of time. But, as again, we're talking now maybe 2015 to 2019, and you have a significant technical pickup in the world as time goes on. It used to be technology existed for I'll go back, I'm a gamer historically, the Atari 2600 lasted for 10 years and then you had the Nintendo. Now it's like a game comes out and then an updated version comes out hours later because of the way that tech works. So as you saw the uptick in tech, you started to see a transition from not just couponers, but now all of a sudden the claims rates went from 9 to 10% to 80 to 90%, sometimes over 100%, which made no sense. So the definitive thing on claim score was I was defending a case in the 2019-2020 timeframe, and at the same time, Farnese and I were prosecuting a case as plaintiffs. And they both settled within a month of each other. So we've got a track that's probably like 60 days apart. The defense case was first. So we move for preliminary approval in the defense case, and it's approved. We get a notice plan, and we start to get claims in. And you start to see these claims coming in 10,000 a day, 15,000 a day. Like, wow, something crazy is going on here. 60 days later, we start the claims process in the plaintiff's case, and the same thing is happening. So now the defense case shuts down with, a 300% claim rate. And, I say to Mark, I'm like, well, look, there's something wrong here. So we need to dive into this data and we need to look into exactly what happened and what was going on. So because, technology was sophisticated then, we kept a digital fingerprint, basically, of every single claimant. And I don't think, even in today's day and age, I'm not sure that administrators keep a digital fingerprint. At ClaimScore and Covalynt, we do, but and at the time, I don't think anybody other than Mark was keeping digital fingerprints. So we kept a digital fingerprint of everything, and we started to look back through the claims and realize that some of these claims aren't being made by couponers. Groups of these claims were being made by entities that didn't even have a U.S. presence. So having no way to do it technologically at the time, because data science, still really doesn't exist in the legal world. It certainly didn't exist then. we did it with pen and paper, and we started to do what now is like geofencing, and we started to sort of look at where these claims were coming from and whether people were blocking their URLs and that kind of stuff. And we came up with some, very, very rudimentary tactics to fight fraud. And in the end, we ended up sending what are called cure notices in the administration setting to several 100,000 people, basically saying, we don't believe your electronic claim. If you really are a class member, we need you to sign this and send it back to us. Here's a self-addressed stamped envelope. And the response rate to that was 1 or 2%, which is what you would expect, right? So you realize they're like, wow, there's a ton of fraud. Now, at the same time, on the plaintiff's side of it, the same thing happens in the plaintiff's case. I was working with one of the best defense lawyers in the country, a guy named Chris Chorba from Gibson Dunn, in that case. And Chris was beside himself that, well, this is crazy. Like, we have a 400% claim rate. Like, we have to do something about this. And I had a co-plaintiff's counsel who was a true plaintiff's counsel. And they were like, well, who cares? If it's 400%, like, we don't care. Like, the more claims, the better. It justifies our fee. And I just couldn't do that. I'm defense minded. So I said to Chris, listen, I'll work with you. I moonlight as a plaintiff's guy. I'm really a defense guy. And I just went through this in a case where I was defending a class action. Let me explain to you what we did. Let's get the data and let's see if we can work on this together and figure it out, which we did, and ended up both cases got approved. Everybody was happy. Now this is maybe mid 2021. So at the same time, I had invested in a online digital fitness app that was AI based with an individual named Brian Heller. And Brian is an engineer by trade and just a super smart guy. I wonder if Heller's team can create an AI solution to deal with this.
Did you know him before you bought the app?
We were introduced through a mutual friend, and he was looking for an investor. So I invested. I met him, and I don't know. I guess I'm one of those strange people that I don't really invest in products. I invest in people. Rick Hendrick, the great NASCAR owner and car sales maven, used to say, companies aren't built with products, they're built with people. And that phrase always stuck with me. So, when I met him, I wasn't really sure whether the app was going to take off or not. It seemed cool, but there was something about him that, it's, oh, yeah, I think I'll do this because somehow this will work out, which is a crazy story because it has. So I called him and I said, what are you doing? He said, I'm down in Florida visiting my father-in-law. I said, all right, well, when you get back, I have a question, an opportunity for you. He's like, well, talk to me now. So I explained what had happened. And I said, I think that as a lawyer, the other thing that happens in these settlements is that administrators, you don't really figure out the claims until the end of the process. There's no real-time look into these claims, right? Because administrators don't make a determination on eligibility until, claims period typically go from 60 to 90 days. Claims aren't validated until the end of the process. So you don't really know as a lawyer, your client's asking you, well, how much is this going to cost me? And you're like, well, I don't know. I'm not really sure. So, it always stuck with me that man, and that's why, with Mark's company, I was able to call him every day and say, I want to look at these claims now, send them to me. I need to make educated guesses for clients who are, have to put reserves in place and understand that they have to either pay a lot of money or not pay a lot of money. And it struck me as we live in the technical world, there has to be a way to use these rudimentary tactics that we talked about, put it into some technical platform and get a real-time result. How hard can that be?
On the call with Brian, I think you said his name, on the call with Brian, does he come up with an idea right then, or does he think about it, take it away?
He's an engineer by trade. So, whenever I suggest something to him, it's always like, this sounds great. Let me think about it. Let me talk to my team and let's see what we can do, which is what he did. So he called me back the next day. He's like, at this point he has I think one full-time guy and 2 part-time people working for him. He said, yeah, I think we could build something. I said, okay. I said, look, I have a few cases that I know are going to settle on the defense side, and I have an admin that we can work with. I think we can test the theory. I said, okay. So make a long story short, they built this product called ClaimScore. It was based off a 1,000-point scoring system. They created a series of algorithms that had a series of criteria associated with them. Every claim was ingested in real time, analyzed in real time, and given a score, almost like you do a credit score. And we set a number at 700, that if a score was 700 or above, the claim seemed legitimate. If the claim was 700, it was 699 or below, We think that there was enough indicia of fraud that the claim likely wasn't legitimate.
You say it's evaluating this in real time and giving it that number. What is it evaluating? What information is it taking about the claim to say, hey, this seems legit. No, this seems fishy.
We take the information that's listed on the claim form. So name, address, telephone number, email address, any other information or data that comes on the claim form. That information is then in real time given to, essentially fed into our software program that is ClaimScore. It is enriched to include about, from the whatever 5 or 6 points of data that we get, we enrich it to have about 200 data points.
About that particular person to see if they're real. Right.
Correct. Those 200 data points are then condensed into about 65 data points, and then the score is based off those 65 data points. So when we were structuring the way we did this, right, there were several things that were important to me as a lawyer. One of which is, one way that we did it when we were doing it with just, pen and paper was, if they came from top class actions, we're going to say that they're fraudulent, and we're going to make them prove that they're not fraudulent. And that's just not the way to do things, right? Because, in a world, if a judge is asking me, well, Mr. Beshada, you got rid of Mr. Maine because he came from top class actions. Like, what basis do you have to exclude something that comes from a website? So it was important to us that we built this in a way that no single criteria disqualified anybody, that it was an aggregate group of criteria that had weighted scores, depending upon how important those weighted scores were, depending upon how important we deemed the information, that we built an algorithm that nobody was ever disqualified for one thing. And I thought that was important from an evidentiary perspective. The second thing that was important is, every time we deduct points from a score, we code it with a deduction code. At the end of any case, we have hundreds of thousands of pages, if you printed them out, of data on every single person who made a claim. So if a judge said, Mr. Beshada, Mr. Maine claims that he's a legitimate person and you disqualified him, why did you do that? I can go into a database and say, well, Mr. Maine, spelled his name wrong. And he gave an address that was not the address that he currently lives at. And the telephone number that he has is not associated with him. And he has this strange email address that has 3 numbers and 3 letters to a Hotmail account. And by the way, Judge, that pattern exists with 100,000 other people who also made claims at the same time that Mr. Maine did, literally within the same 5 minutes of each other, right? So you want to have evidentiary support when you're telling somebody in a class action that they're not entitled to participate, because generally speaking, the theory behind class actions is, if you're a member of the class, you're entitled to compensation. So we wanted to build it with a legal evidentiary framework. And that's what Brian and his team did. So I brain dumped all of that to Brian and his team, and he spent 6 to 8 months sort of building a platform that we then tested.
And what year was the first case where you actually took this product and what it established to the court to facilitate the settlement?
2023. We did 6 cases.
And then in your marketing material, you mentioned the Apple case, and the judge says, well, I don't have confidence in what you're giving me to prove this class settlement. It seems to me that courts now, because this kind of data exists, that this is what they're buying into now. Are most courts requiring this type of stuff, or is it where you still getting the word out and it's still an uphill battle?
Still getting the word out. I think that the Apple case, a little bit different context, because that was at the class certification stage. But I think the theory applies exactly as you suggest, that fraud analysis in these cases ultimately comes down to one thing, and that is data science. And what we've learned so we did 6 cases in 2023. We did about a dozen cases in 2024. And then we did about 60 cases last year.
When you say we, it's not you, it's other firms now. It's not, you had the original 6, I think you said. You've got other firms doing this stuff too, right?
From a claims court perspective, yes. So in the first year, we had just 1 administrator client. In the second year, we had 2. And then last year, we did work for, a dozen or so administrators. So the word has gotten out to a certain degree. And we've been involved, in 2025, I think probably in the top 20 largest settlements, we were involved in half of them as the fraud expert to do this. And the product has developed over time. We started with a beta version, or we started with a test version, then we did a beta version of the product. And again, Brian is a very, very dig down, understand it, make sure it works kind of guy, and as am I. So we wouldn't put anything in the marketplace that we didn't know worked and wasn't through a series of rigorous both internal and external testing. So, we took our time to do it, we think, the right way. But fraud, ultimately, as we see it today, it's a data science problem. And I think what happened is no one really focused on this until we came along in 2023, 2024. And now, a bunch of other people have patched together what they call anti-fraud solutions that aren't based in data science. And I think as a result of that, we are regularly called on to review other people's fraud solutions and other people's determinations.
The mission statement is to bring scientific rigor, engineered precision, and defensible clarity to every stage of complex litigation by uniting legal expertise with advanced data science and systems engineering. That's what you're bringing to the table when you're asked to review these other settlements.
That's exactly right. So we're asked to review it, and we look at it, and there are things going on now in the space where just certain administrators are actually blocking people from making claims, which I think is crazy. None of that is ever disclosed to anybody, but that's how people are dealing with fraud. And I think, as we get into the transition to Covalynt discussion, what it really comes down to us is data science. And if you look at how fraud is done in the banking world, in the big finance world, it's all done through data science because it's pattern recognition analysis is what is good fraud detection. We won an award last year, the American Banker Award, along with one of our partners is a company called Digital Disbursements, which is a subsidiary of Western Alliance Bank. And we won an award with them for something that we call the anti-fraud triangle, which is front-end solutions to weed out potentially fraudulent claimants coming in, data science and pattern recognition analysis that we provide, and then payment fraud analysis that the bank does on the backside. And at that conference, the head of Fifth Third Bank's cybersecurity did this coffee side chat presentation, which I thought was done really well. And they were talking about fraud, and everything he talked about was pattern recognition analysis. You can't do pattern recognition analysis unless you're doing true data science.
Do you have data science on the team now? What's the makeup of your team now?
So we started with, just one person and 2 part-time employees, and we now have 22 employees, 16 of which are software engineers and data scientists.
And the name change, Covalynt, how does this come about? Because you got other products, which I want to get into, but let's start with the name change.
We determined that, we were no longer ClaimScore because we had multiple other things that we were doing. ClaimScore was simply a software solution within our suite of products. And that's how we ended up changing the name to Covalynt, because we now offer solutions that are not just anti-fraud stuff. They all have the same, the technology foundation for each of them is somewhat similar. But we become a data science kind of identity resolution company that is purpose-built for big ticket litigation. When we were doing some fraud analysis for one administrator, one of our good administration clients, a company called AB Data, when they were administering some cases, they had some other data science questions, and they started asking us, well, from a tech perspective, can you guys help us with this? And is there any way that you guys can streamline this process? And it opened our eyes to a whole other series of technology solutions that weren't necessarily fraud-based, but were data science-based, that we could use our identity resolution. Basically, what ClaimScore became was an identity resolution and an identity verification platform for class actions using data science to make those determinations. And that same platform could be utilized the other way. Example, they had a case, or there was a case, where they had a lot of undeliverable emails, big class list, and a lot of the emails were undeliverable. We're able, through our relationships with third parties and a lot of the first party stuff that we do, we're able to take an email list, enrich it, and update it to get new email addresses for people who, maybe the emails are now deliverable. So that became something that we looked at. We did it a couple of times and said, wow, this could be an interesting product. We put a team together to develop a system that we now call deep validation, which means we can take an email list, and now we can automatically take an email list, ingest it, leverage our sources and our identity algorithms internally, and spit an email list back to you that says, well, Chad Main's email address of cmain@yahoo.com is an email that he hasn't used in 5 years.
Oh, interesting.
Try cmain at legaltechpodcast.com, right? And that we know from what we do that that's an email address that you have used on the internet within the last 30 to 60 days. So we started to see these other solutions that had application in the administration context. And using data science, you're able to take that information, update it, and make the process, much more accessible, much more efficient, and much more cost effective.
Including on the front end too, right? You use it now. You have a product called Class Resolution where it helps certify classes. How does that work?
So on the class resolution side of it is somewhat similar to what we do with deep validation, and we are able to take, so for forever, I guess, people have had what we call fragmented data. So fragmented data is just simply data that's incomplete. You have a data set that's incomplete. Sometimes you have just a URL. Sometimes you have just an IP address. Sometimes you have just a name without a phone number or an address. And on the class side of things, you're required to show as a lawyer that your class is ascertainable.
Explain what it means to certify a class, what the lawyer's got to prove. Because you just can't go into court and say, hey, I got 1 million claimants suing for this. Like, what do you have to do to prove to the judge?
It's a formula, right? So you have to prove to the judge that there's a group of people that are similarly situated, meaning that they have similar things to each other, that those people are actually reachable. That's the ascertainability factor that goes to the class resolution, and that you can reach and they can make claims. And you have to show that it's a cohesive kind of unit. So in the context of the Apple case that you mentioned, it's the Apple antitrust case. That was a case that went on for a long period of time. It involved payment of what the lawyers considered kind of like a VIG from the App Store to utilize apps and some in-app purchases that Apple was taking some money from. And the lawyers filed the class action, and this is just general, right? The lawyers filed a class action seeking compensation for anybody who was an App Store member that was charged a certain fee by Apple. Apple argued that that class was not ascertainable because there was no way to identify the actual class members because there weren't records or there wasn't enough data to put data together, okay, to identify who was who. And one of the things that you're required to do when certifying a class is show that there are class-wide damages. So the Apple case actually was certified by a judge, and the judge said, and again, I'm skipping over a lot of things. It was a long time piece of litigation, but the issue is the case was certified, and the case was certified on about a $20 billion damage theory that class-wide damages were about $20 billion. The judge certified the case and said, now, I'm going to tell you that at some point you are going to need to provide a method by which you can actually identify people that you can then reach out to provide them the damage money, if you win a trial, the damage money that they're entitled to. And to make a long story short, the plaintiffs did not use data science as a theory to identify class members. They used an old school approach. What in essence Apple said here is we don't necessarily have contact information. We only have Apple IDs of people. And they had to do what was called a complex matching analysis to try and match Apple IDs to real people. That requires sophisticated data science in order to do it and do it correctly. And the plaintiffs in the case didn't do that. They used an administrative tool that has been used to do some rudimentary matching on notice side over time. And Apple moved to decertify the class, saying the way to identify class members sounds in data science. It doesn't sound in basically napkin matching. And the things that happened when you don't do it through data science, in this case, one example was there was a town of 500 people in Alaska, and it was determined that there were several 100,000 claimants that lived in that town. Right? Which, if you did the analysis through data science, you would see that anomaly in the data, and you would be able to deal with that anomaly in the data that, okay, I wonder why that it can't possibly be the case, right? And since, that was one example that Apple used to say this method that they use to identify class members or to identify class-wide damages has no basis in science and no basis in reality because there are significant mistakes that happened, and this class can't be certified with all these mistakes. And the court agreed, saying, data science is the way to go.
That raises an interesting point about ultimately sales, but getting the word out about this. It seems to me like you've got two, or at least two audiences for this app. You got the administrators, and then you got the bench. It seems to me that it's very important to get the bench to buy this, because if I'm a judge, it seems this is the gold standard now, or it's the only standard, right? It seems like what you created here in this data science is like the only real true way to answer these questions. So when you're going to market, from a marketing perspective, from a sales perspective, which one's more important? Letting the bench know about it, or letting the administrators know about it, or letting companies know about it that are getting sued? Like, how do you get the word out? What's the best way to do it?
For us now, the big data companies, they have sophisticated data scientists that they work with. To us, going to the lawyers is the best way to get the word out. And we're now working directly with a bunch of lawyers on data science projects. I think the bench comes afterwards. And I think, the way that we like to do it, or the way that we're doing it, is, it's marketing through education. So we're spending a lot of time getting in speaking engagements. We built an entire CMS system in-house where, we're tracking every single class action that's filed and kind of segmenting them into what are cases that, you could use data science in. The way to get the word out is, I think, you need to go to the lawyers, and we need to educate the lawyers that what we know exists in today's day and age, right? And I think that data is an important aspect of every part of our lives. And as remember I said earlier, that the legal world lags 5 to 8 years behind. Every single class action that's filed has a data problem. And every single class action that's filed that has that data problem can ultimately undo that class action for a group of plaintiffs. When we say this to people, then when we talk to lawyers now, if you don't have a data science company in your Rolodex that you're talking to early on in the process, ultimately you're going to miss something. And that something you miss could be the thing that costs you a $20 billion case like it did in Apple.
That's an interesting point too, because it cuts both ways. It's important to defense counsel because, right, they want to save their clients money. They don't want to pay fraudulent claims, but it's also should be important to plaintiffs counsel, to your very point. So they have an airtight case. Look, here it is. Here's the class. Here's the claimants. How can you not certify this, or how can you not approve the settlement?
If you look at the Apple case, again, I think as time goes on, we'll look back and realize that I like to talk about it as inflection points. I mean, this Apple case is going to be an inflection point at some point, because what Apple did is they took data science and used it against the plaintiff's lawyers and won, because the plaintiff's lawyers, they went to war with a water pistol while Apple had a tank, right? And in different settings, we're now involved in a case in California with Meta. And it's a jury verdict, and they need to figure out, who's in the class. It's a class period from sometime in 2016 to 2019. They have to be California people. And it's difficult to figure out who those people are if you don't have a data science approach. So we got retained, and that case is moving its way through a post-judgment proceeding. But interestingly, in that case, in court, the defense lawyer, when we were introduced as working with the administrator and the plaintiffs, the judge asked the defense lawyer, I don't really know about these guys. What do you know about them? And the defense lawyer has used us on the anti-fraud side and sought to use us in this case, but we had already been retained by the plaintiffs. And he got up and said, well, Judge, I'll tell you, I've worked with these guys. They're great. The plaintiffs didn't hire them. Meta was going to. We like the fact that they're in the case. And the one thing you have to remember about data science is it's not a partisan issue, right? So we like to say that whether we're hired by the plaintiff or the defense, the result is going to be exactly the same. It doesn't matter. We're not advocates for one side for the other. We're advocates for the truth. We're advocates for accuracy.
That's such a great point, and unique point. You're not partisans because, as we all know, expert witnesses, you got your defense ones, you got your plaintiffs ones, and it is partisan. But it's data science, and it cuts both ways. It supports both ways. It's really interesting.
When you look at it, there really is only one real way to do things properly when you're doing it. That's why it's science. And the law, you can argue things one way or the other, right? When it comes to data science, the data tells you everything that you need to know. You need to be able to take that data, put it in some type of usable format, and analyze it in the right way. And that requires a sophisticated area of expertise that, candidly, nobody in the space has. Getting back to the point of ClaimScore to Covalynt, when we were doing only fraud stuff, we had this product called ClaimScore. As we got into doing other things like the deep validation and the class resolution side of it, and in our bespoke, solutions. It's like, we'll get a call and say, we've got 40 million records. We don't really even know where to start. Data is all over the place. We will create something and say, well, okay, we can streamline the records for you. How do you want the data presented to you? So we create little solutions that streamline the process.
What's on the roadmap? We talked about the products you have now. What's the plan? What else are you working on?
On the claim score side of it, we've probably done 35 or so different versions of that. As things come in and as fraud patterns develop, we continue to update the system as any, if you have iOS, right, you see you're on iOS 100.8 or whatever it is, right? So we continue to update that and continue to hone that. We're getting more into the class resolution side of it now, where, we're being asked by plaintiffs' lawyers, we only have certain fragmented data. Can you enrich that data and build classes for us? Which is an interesting kind of thing that we're starting to do. The deep validation stuff is just starting to take off, where we're actually taking notice lists. And in the regular world, what you would do is, if you had an undeliverable email, you'd spend 65 or 70 cents to send a postcard out. Now, with rejected emails, we can actually do a technological analysis to get a better email for somebody that costs 10 cents. So saving a lot of money, sort of doing that, developing that. We started to do some work in the mass tort space on lead gen, where we have one firm that what we've created a solution for, where on the lead gen side of it, we're doing like basically a fraud check up front on the lead gen side of it. So we're saving that firm and their team, an unbelievable amount of time chasing down things that aren't like legitimate leads. So we're, kind of getting more into the mass tort side of it on the lead gen side, where we think, we've done now kind of a before and after analysis of before they had us and after they had us. And, they're probably 10x time more efficient by utilizing technology on the front side of it to streamline the process for other people. So that's something that's on our roadmap. I think one other thing that plays a role is we have developed, along with digital disbursements, a program that we call Quick Pay. And because we can analyze and validate claims in real time, the way that the process has worked for class members is, you make a claim and you get paid 7-8 months later. You get a check in the mail, or you get a Venmo payment. And we've now developed a solution where we can actually offer immediate payment. There's a risk associated with that, so it's kind of like a financing of those claims. And again, there's a big finance play in mass torts that works, but it's not not us. A finance company was interested in, could we do real-time analysis and let them know whether a claim was legitimate or not. They would then offer to front the payment to the class member, so they don't have to wait 6 or 8 months for a small piece of the action. And it's basically an advance pay thing that exists in any number of arenas. It's a technical integration that we need to have. So we've tested it in one case. It actually worked relatively well. I think the people who got the advance pay were really satisfied with it. But it's something that we had on our front side of our roadmap, but now has kind of gone down the list as we sort of really focus on this class resolution side of things.
You got to follow the money.
Yeah. The class resolution side is really, again, the Apple case really kind of opened our eyes to a lot of things. And again, I think that's one of those cases where we're going to look back on it from some point and say, wow, that was really an inflection point. The other thing that we're doing a little more consulting. So it's not just, on discovery requests, right? It's not as simple as just, let me have IP addresses, right? There are technical requests that you're going to want to make to get in deep into the data that we've done some stuff on. And I think, on our long-term roadmap, I believe that at some point in time, given the prevalence of data in our lives, that you will no longer need to do the advertising stuff that we talked about early in this discussion, that you have to go advertise a class action. There is enough popcorn to build a trail from your purchase of Walmart to your utilizing that product and then being a member of a class. And I believe that at some point in time, we are going to use data science to connect all of those dots. And we're starting to do it now. We have a case where we're testing a beginning theory that we don't need to do any advertising notice, that if we can get X pieces of data, we believe that we can connect retail purchases directly to people without having to expend hundreds of thousands of dollars advertising. With the goal being to streamline, make the administration process more transparent, more efficient, and ultimately more cost effective for everybody involved.
Darn, appreciate your time. This is really cool. What I love about the app is, a lot of legal tech is getting the legal work done, helping lawyers get the legal work done. But this is actually a technology that you take to court and helps prove a case or disprove a case. It's cool. It's a cool use of tech. I appreciate your time. If people want to get a hold of you, learn more about your products, learn more about your company, where should they go?
Covalynt.com, Covalynt.com. And you can fill out a form from there if you need anything for us. And I agree with you on the legal tech side of it. I view a lot of legal tech as what I call solutions of convenience. And
Yeah.
this is an actual technological solution that solves problems that I think are going to become more prevalent as time goes on. But listen, this is great. I listen to your podcast all the time, and I really appreciate you
Thanks
letting
for
me
listening.
come
I
on
appreciate it.
and talk about this and have a lot of fun. Thanks a lot.
Okay, that's a wrap for today's episode. As always, we really appreciate you listening. If you want to subscribe, you can find us on most major podcast platforms like Apple, Spotify, Google, Stitcher, etc. Also, if you like us enough, I hope you leave us a favorable review. Thanks again for listening. Until next time, this has been Technically Legal.